Okay. Welcome to the afternoon docket of the Kansas Court of Appeals. I'm Chief Judge Karen Arnoldberger, and I am joined today by former Chief Judge Thomas Malone and with Senior Judge Richard Walker, who hails from the 9th Judicial District, where he was a district judge for 31 years before he joined us as a senior judge on the Court of Appeals. So we're happy to be here today. If the parties would state their appearances, please.
Your Honor.
Go ahead, Scott.
No, I usually go first because I'm the claimant, but this is your appeal. I apologize.
Your Honor, the respondent appears by counsel Shane Bangeter.
Okay.
The appellee, the claimant, I'm sorry, the appellant, the appellee, and the claimant.
Yeah, you're appellee, I think, this time.
Appears by and through Scott Mann, and my client, Stephen Langvardt, and his wife, Jane Langvardt, are actually in the room with me listening.
Oh, okay, great. Now you guys have me confused. Mr. Bangerter, did you wish to have any rebuttal time?
Yes, I'd like to reserve probably 5 minutes.
Okay, so you'll have 10 minutes regular argument, 5 minutes rebuttal. All right, as you all know, we have read the briefs and are familiar with the facts of your case. So since you have a limited amount of time, if you want to forego a factual recitation at the beginning, that would be great. But with that, Mr. Bangerter, you may proceed.
Well, thank you, Your Honor. As I mentioned, my name is Shane Bangeter. I'm an attorney in Dodge City, Kansas. I represent Innovative Livestock Services and the Kansas Livestock Association in this matter. I've represented and had the privilege of representing the Kansas Livestock Association for nearly 20 years. And it's just great because these are just salt of the earth people and their employees even more so. Oftentimes, their employees will come to a settlement hearing of their workers' compensation case, just like the one that we have here today before us, dressed in their Sunday best, their pressed blue jeans, cowboy boot, cowboy hat, and a fastidiously groomed Manchu mustache. And that's very, very typical in these workers' compensation cases. How these cases are resolved and how the process works. This case was very typical. I would say over the years, I've handled a couple thousand or more workers' compensation settlements. It's really the only definitive way that a workers' compensation case gets closed. And so in this case, it really is the final order of final orders if this court finds that the settlement hearing is valid. Likewise, Attorney Mann, he's a few years older than I am and has been involved as long as I have, probably has been involved in thousands of workers' compensation matters as well as Judge Richardson, who some of you may know. Judge Richardson, when I first started practicing law in 1990, he was the administrative law judge that I cut my teeth on trying to learn workers' compensation cases. Had the privilege of trying many cases before Judge Richardson, before he then went on the bench as a district judge, and has since, for approximately 10 years now, since he's retired as a district judge, been a special administrative law judge where he handles many hundreds of settlement hearings. It's not unusual for me to have 4 or 5 settlement hearings with Judge Richardson a week. And I'm just one lawyer and many others practicing in front of him. So the combined total of experience here between myself, Mr. Mann, and Judge Richardson is pretty amazing, actually. As you can see from the settlement hearing, it's not a hearing on the merits. You're really having the hearing, and there's almost always a compromise settlement. There's almost always issues that were compromised in order to get there. in order to settle the case. And clearly in this case, there's no exception. There were issues in the case in regards to the body parts that were injured as a result of the accident, the extent of those injuries. And that really is the crux of the appeal, is that the claimant has now changed his mind and wants to come back and litigate the issue as to whether or not his back was injured as a result of his workers' compensation claim. But clearly that was an issue that was.
Why don't you, counsel, could you please jump into the jurisdiction issue that we have?
Yeah, so that really,
substance?
That really gets to the issue of whether this is a final order. And as I mentioned, it really is a final order of final orders. This is how workers' compensation cases are closed. And if this court affirms Judge Richardson's award, then it closes the case and it's done. And it's
well, that seems to, you seem to be begging the question. You're saying it's a final order if you win this appeal on the merits. But where we're at right now, the last order we have from the board is remanding this case back to the ALJ. How can that possibly be considered final?
So what he's doing is saying, I'm sending it back to be decided on the merits. They're saying that it wasn't final under the law. But I think when you see the things that Judge Richardson had in front of him and the issues in front of him, this is a final order. And if you agree that it is, it's done. This is the end of this case. It will never come back again. Issues are closed.
So are you saying that if for example, this goes back to the ALJ and the ALJ enters an order with regards to compensation, and you then appeal that you will never be able to raise the settlement issue at that time?
I think the settlement issue becomes a moot point. Once you start having to litigate the merits of the case, the settlement really doesn't become relevant to anything. And so we'll be litigating the merits of the case unless you find that Judge Richardson was acted appropriately and affirm his opinion.
As I understand it, you're not really saying the board made erroneous decisions on or that their conclusions were incorrect. You're just saying the settlement trumps all further discussion. Is that kind of the bottom line here?
No, I think what you'll find is that the basis that the board used to set aside Judge Richardson's award is really completely irrelevant. This isn't, the issues don't involve work disability. The issues don't involve whether the award was calculated correctly. The issues don't involve whether or not the person had a capacity to enter into it. Those issues have never been raised. The only real issue that they're appealing, and the reason they're appealing, is they want to relitigate and uncompromise the issue of whether the back is compensable under the work comp case. That was clearly an issue at the hearing, subject to the medical that was presented, and also an issue that the claimant fully was aware of, said he knew about that. It was a compromise after he discussed all those issues with his attorney, and now wants to change his mind, set the thing aside, and relitigate that issue, which I think is clearly inappropriate after you've had a full and final hearing and given all the safeguards that are in place, which I'd be happy to discuss as to why this is a very serious matter and why you need to consider all those things and why we have all these protections in place in Kansas to make sure that when you get to a settlement hearing, you understand your rights, you understand the terms of the settlement, you understand what you're giving up, you understand all the issues that you've compromised. Many times
I understand that Mr. Langvardt was in a hospital room when this case was settled. Is that an appropriate time and place to be settling a workers' compensation case?
Judge, Mr. Langvardt had been in the hospital for almost 9 months. He received these documents, talked to his attorney, fully was capable of understanding the terms, the compromise he was giving in regards to his back. And that has never been an issue in the case as to whether or not he understood the terms of the settlement, had an opportunity to talk to his counsel, compromised the issue on the body part, agreed to the amount of the settlement, and agreed to close his case. So, no, I don't think that's an issue in the case. And it hadn't been for almost 9 months.
Only got a couple minutes left on your time.
Thank you, Your Honor. These settlements are serious business, and they shouldn't be taken lightly. Built into the system in Kansas are numerous safeguards. You have to have a hearing. You have to present the terms of the settlement. Those have to be reviewed. If they want to seek assistance of counsel, they can. And so we have a very good system in place before the settlement hearing. But after the settlement hearing, we need to have the ability to have some certainty, some completion, and some finality for all parties. And in this case, it's clearly, the issue is clearly whether the claimant can just basically refuse to accept the payment that was tendered to him and was offered to him, and he accepted the tender of that settlement check. So the issue in this case is really, can someone just refuse to accept payment, change their mind, and then want to relitigate the compromised issues? And in this case, I think that's clearly not appropriate. You can't just after you have a hearing, refuse to accept the payment and change your mind. If that were the case, how long would that last? Can you just refuse payment for a week, an hour, days, months? Can you then take possession of the check, but then hang on to it and then try to settle your case or not settle your case? There's just so many problems that this would create if this court were to hold that this payment was not made and allow claimants to then be able to back out of these settlements by either refusing to accept the check or refusing to negotiate the check.
I have one real quick question. Your time's up at this point, but so there was a hearing in front of the board, right?
Yes.
And at that hearing in the board, you, I'm assuming, presented evidence as to why the settlement agreement should be kept in place. And Mr. Mann presented evidence as to why he should not be bound by the settlement agreement, correct?
Correct.
And the board reached a decision on that and remanded it to the ALJ. Now, and this kind of goes back to my question initially. Let's say, for example, then that the ALJ gives an award that is much higher than the settlement agreement, and you appeal to the board. I guess I'm trying to figure out at what point would there be appellate review if we decide we don't have jurisdiction on this? Is there a point of appellate review of that, of the denial of that settlement agreement? Does that make sense?
Yeah, I think so. I mean, obviously, if there were nefarious means, fraud committed, those kinds of issues, that would clearly be something. You could think of a number of issues that might be subject to review. But really, what I think and what the cases have said is, yeah, it's subject to review. And you look at and determine if all of the things that I talked about, the claimant knew what was going on, understood his rights, and all of that.
The settlement. I'm just trying to figure out what is the appropriate means of, if we don't have jurisdiction, what would be the appropriate means of relief if an insurer was questioning, believes their settlement agreement should have been adhered to?
Yeah, so I think it's
Maybe
clearly,
Mr. Mann can answer that in his discussion.
okay.
Okay.
I have one quick question. I'm sorry, I should have asked this earlier. I just need some clarification and some clarity on one thing. Are you saying the board did not have the authority to say the settlement agreement was not in the claimant's best interest, or they abused their discretion? Because it seems to me that's an important distinction.
Yeah, I think based on the facts of the case, that the board clearly missed what they should have been looking at. They based their decision on whether or not the judge asked about a work disability. That's not an issue in this case. They based their decision on whether the award was calculated correctly. That's not an issue in the case. And they based the decision on whether the judge should have asked whether the guy was under some influence of medication or something. That's clearly not anything that they've alleged or are asking about. And really the only determination then is in regards to best interest is what the claimant testified to in the hearing. And that is clearly of record in this case. And he fully understood that body part was not included. And now he wants to come back and litigate that issue. So I just think
like you're saying abusive, that they abused their discretion. Is that fair?
I think so, Judge. I think that they just missed it and they considered all the wrong things. And if they considered the right things, they would have affirmed Judge Richardson.
Okay, thank you.
Thank you. Mr. Mann?
First, to address Justice Walker's question, I think Shane and
I've been promoted.
yeah, Judge Walker, sorry. I think Shane and Mr. Bangeter and I agree that the board has authority to review settlement hearings, and that's there are very few cases on this. So I guess Mr. Bangeter's argument that we're opening Pandora's box, I think is premature. But the Grajada versus Aramark case, 35 Can App 2nd 598, it's a 2006 case. That specific issue was left to the Court of Appeals, and they said that the board has the ability to review settlement orders issued by special administrative law judges. So clearly the board had authority to review this. The question by Judge Arnold Berger was, what's the appellate rights? I think that's a bit grayer. I think that actually you have the ability today to determine whether there's substantial evidence to support the board's findings, and there are two findings there. But if you would find you do not have jurisdiction, the case has been remanded. And Mr. Bangeter keeps saying to relitigate. It's never been litigated. My client is asking permission to litigate the issue on the basis that the settlement was not appropriate. And I think Mr. Bangeter's client could then reserve that issue of whether the settlement was final throughout the litigation again. That could be a reserved issue. And just as the issue of is the award by the administrative law judge appropriate? Is the award of the Workers' Compensation Appeals Board appropriate? And then those issues could be brought back before you at the end of the case again. But going back to more of the merits, the board made two findings. And I think if you uphold either, then the set-aside order should be affirmed. And the first one, I think, is just the basic. The statute's very clear. Upon payment of the settlement, the respondent will be released. And so the issue is whether there was a payment. And again, the facts are very basic here, very limited. But at the time of the settlement hearing, my client was in the hospital. He hadn't been in the hospital 9 months. This would have been May. He would have been in the hospital. He had back surgery a second time in April, so he'd have been there about a month. He was at Madonna Rehab Hospital. I'm not sure that's important. But so he couldn't attend the settlement in person. And at the end of the settlement hearing, Mr. Bangeter made the announcement that the check had been mailed to the employer. So we know my client didn't have possession of the payment. And it was left up to the claimant to make arrangements with the employer to receive the payment. There was then a stipulation, and you can see this in the board's order. Unfortunately, the board is not a court of record. So really just argument is presented to them. There's no evidence presented to them. But they asked, because Mr. Bangeter was raising the fact that payment had been made. I was raising the fact that payment had not been made. And so they asked, I mean, will the parties stipulate that Mr. Langvardt contacted the employer within 24 hours of the settlement hearing? We actually think it was within an hour of the settlement hearing, and advised the employer he was not coming to get the check. He did not want the check mailed to him. He was not going to accept the settlement. So the statute's very clear. There's been no payment made here, and therefore there's no settlement here. And there is evidence to support that. The second finding, the judge is tasked, and there are safeguards. I mean, I've done thousands of settlement hearings, but there are safeguards to protect the worker. And one of the safeguards is the court has to go through certain things to make sure that the settlement is in the best interest of the claimant. And I would say when the claimant's represented by counsel, I don't want to say those safeguards are shortcutted, but they, again, one of the questions is, has all of this been explained to you by your counsel, and you have legal counsel representing you? But when you're dealing with a pro se claimant, and again, Mr. Bangeter, I think it was a misstatement, said he had had plenty of time to discuss this with his counsel. He didn't have counsel. He appeared at this hearing without counsel. So I think then the administrative law judge does need to make certain inquiries as to whether the settlement's in his best interest. And one of the main things that should have been asked is, had he read Dr. Estivo's records, and did he understand his medical condition? That was never asked of him. There are some documents that were attached that he had initialed, but they weren't even referenced by the judge. Whether he had read those documents, whether he had understood those documents, whether he knew what he was doing when he was signing those things. The board then points out, just as this court has, that my client was in the hospital at the time of this settlement. And when that was brought forward, the administrative law judge, again, because we're dealing with a pro se claimant, should have just made the basic inquiry as to whether he was under medication and whether this was, again, in his best interest to settle the case, given the fact that he was in the hospital. So there are just some basic findings that were made by the board. Again, the payment issue and whether the settlement was in the best interest of the claimant. You read this record and it doesn't establish either. And so I think the board's decision, the board had two choices. The board could have remanded the case and asked for more evidence on these issues. That's what they did in the Grajada case. The board felt strongly enough about this case on these two issues that it just set aside the order and remanded the case. So it didn't ask for more evidence on whether the settlement should be set aside or what was said in the settlement or any of that. It just set aside the order. And again, these safeguards are important. They're in place. Everybody knows the rules. And, if you follow the rules, the settlements will be approved. And when payments are made and they're made promptly, they won't be set aside. But under these facts, the settlement was properly set aside by the board, and there's certainly evidence to support that.
Mr. Mann?
Yes.
If the check had been mailed directly to your client, and I realize he was in the hospital, so maybe he couldn't have signed for it, but if it had been signed for by certified, a registered letter, certified mail, and he'd accepted receipt of that, would this be a different case?
I think they'd have a better argument. In the good old days, Shane and I are kind of long, Mr. Bangeter, I apologize, are long in the tooth on this thing, but they used to present settlement checks at the settlement hearing. And that's never the case anymore. I don't get settlement checks for months. Not all the time, but they're never present at the hearing. So the bottom line is the evidence in this case is the employer had the check. My client, the check was never mailed to my client. He never received the check. He certainly never negotiated it. I mean, I think if you take that one step further, had my client negotiated the check, payment had been made.
Okay.
That's all I have. Thank
That's
you.
all? Okay. You have 5 minutes in rebuttal.
Thank you, Your Honor. With regard to the payment, as Scott mentioned, this really isn't unusual how we do this now, and particularly under COVID. Claimants aren't present. The checks are going to have to be mailed to individuals. And so this really isn't unusual. And claimant agreed to accept the tender check, either picking it up at the employer himself or someone else, or arranging for it to be mailed. And so it really isn't a question of whether the payment's been made, but whether the claimant can refuse to accept payment. And that really gets to the crux of the issue. And then you get to, okay, as the question was, what if he actually did get it? Does that change anything? And in my mind, it really doesn't, because it just delays the opportunity for someone to come back and say, I haven't gotten the payment, I haven't negotiated the check, and I can therefore go back and open my workers' compensation case up. That could extend well past the appeal time period, because if the issue is if the settlement is valid only after the check has been cashed, you can think of a number of times where the claimant could get cold feet and hold the check for a while, or not pick up the check as instructed. Oftentimes I'll have the check here at my office, and under COVID now, we will go out into the parking lot and give it to them so that we reduce any kind of exposure. But say that claimant doesn't show up for a day, a week, a month, several months. Does that then mean the settlement isn't final? Can the claimant then come back and say, I haven't gotten payment, and set aside the settlement and then relitigate the case? So I think clearly in this case, payment has been made. The question is, can you refuse to accept the payment that has been made? And I just don't think that would serve the state well and serve justice well in this case. With regards to the medical records, clearly in the Form 12, there's a statement in there that the claimant is stating and verifying that they've read the medical records, they've had the medical records read to them, they understand the medical records. And then going a step further, and almost all respondents across the state have a similar Form A that I have here, that basically says, yes, I've read the medical records, I understand the medical records, I've had an opportunity to ask. And in this case, it even went further, because claimant said that he had contacted an attorney, and the attorney had advised him that he didn't have to be present at the work comp case. And so clearly in this case, the claimant was very well aware of all of the issues. He was very well aware that he was compromising the body parts that were included. He agreed to accept the settlement, and payment has been made. He's just refused to accept the check. And under those terms, I would ask the court to determine that Judge Richardson's findings were appropriate and affirm his award. Thank you.
Okay. Thank you all very much for your argument. If there's no further questions from the panel, we'll conclude this case, and we will